Welcome everyone to the MyHR 16th live topic. We're talking about difficult employment relationships today. The first thing we'll do is talk about some housekeeping just to set some ground rules and make sure all our expectations are aligned going forward, which sounds very formal. I promise it's not. If this is the first time you've been joining us, welcome. We're very pleased to have you. It's a gorgeous winter's day in Auckland, and so I hope the weather is nice for you wherever you are around the country. So housekeeping, we're trying something new today. We've been using handwritten paper-based title cards for a while. The feedback's been really positive, and so we're going to go high-tech and make sure that they're built into the feed. So as we work through, different title cards will come up and let you know what the next topic is or what the next point is we're talking about. This will hopefully also make it a more useful resource for those of us who are watching it after the fact, so on YouTube or on LinkedIn. So bear with us as we test out something new in our live streams. Questions I'll answer at the end, so if you do have anything you want to ask, you're very, very welcome to. We'll wrap them all up in one go at the end because there will probably be some similar themes. Because this is a session that's recorded and it's put on our social media, so on our YouTube channel, on Facebook and on LinkedIn, if you are asking questions, be mindful that they will be recorded, so don't use any identifying details to make sure that nothing uncomfortable gets captured that you don't want being captured. So we'll jump straight into the content today, managing employment relationships that are difficult, and the topic itself is managing your way out of a difficult employment relationship. So as all of you know who have ever worked with humans before, there are lots of different ways that a relationship can go sour. We'll be talking through a couple of different scenarios and talking about the tools available to you to manage those situations. Of course, not every tool will be appropriate for every situation. That would be far too convenient and far too easy. So if you do have any questions, again, ask them at the end or give us a call if there is a particular situation you're looking at managing. So, relationships can turn sour for all kinds of reasons. So whether it's poor performance, whether it's a bad fit within the team, whether someone's been promoted to their level of incompetence and they're not delivering, if there have been changes in the business and maybe some of your long-timers are uncomfortable with those changes or not really into them, or whether this person's just a dickhead. I mean, the list goes on, right? So there are all kinds of triggers that can mean a relationship goes south. For the purposes of today's conversation, we'll assume that you've tried other kind of lower level reasonable ways to manage the situation. So for example, if they've been promoted to a role that is too big for them, looking at stepping them out of it temporarily or permanently. If there's some bad blood in the team, doing some mediation or some relationship building exercises. If it is a performance issue, working with them to see if there are things you can do to support them, or re-looking at your hiring criteria and what happened if you have hired a bit of an arsehole into your business. So assuming that you've tried those things and you haven't really got any traction, the steps you take to manage a relationship where the relationship has gone sour will depend exactly on what's happened and will depend on the outcome that you want. If you think it's a recoverable relationship, the way that you manage that will be quite different to if it's a relationship where you're just kind of burned out, you're at the end of your patience and you really just want this person gone from your business or from your team. So in terms of some options available to you, the first is always telling them to get lost, telling them to go away, firing them on the spot, telling them to collect their things and go. You can always do that. And that may be a surprise to hear an HR person say, because it's not legal to do that. But of course you can. It's not legal to avoid paying taxes, but lots of people do it. And I'm not encouraging tax evasion, and I'm not encouraging doing illegal things with your people. But if you don't want to deal with the process and the hassle, you can always choose to take the risk of just telling them to get lost. That's always something you can do. We just don't recommend it. Stepping back from just firing someone, of course, you can always manage it softly, so using informal discussions or polite feedback about someone's behaviour or their performance. Managing it more firmly, stepping up the pressure a little bit, would be something like a record of discussion, having a formal conversation. Up from there, of course, is the disciplinary process that we'll talk a lot about today. So that's basically performance managing someone out of your business. At some point, you also might choose to offer them some go-away money. So you'll put a settlement together so that they leave your business. The process and content for today is that we'll talk in depth about the disciplinary process and then cover off the other options at the end. The question to ask then is what is a disciplinary? If you've not used them before, it can feel quite admin heavy, and if you have used them, this will be a good refresher to remind you of some of the key points to tick off which back up the advice that we give our clients. So at a basic level, a disciplinary is a tool available to you to manage poor performance or inappropriate behaviour. It's not about punishing the employee, although in certain circumstances you might really feel like punishing them or giving them a bit of a shake. The point is to send a clear message to the employee that that behaviour or that performance is not acceptable in their role or in your team. And of course, the point being that their behaviour then changes. They become a role model team member. They become a fantastic performer that you couldn't imagine delivering without. So that's why we advise pairing disciplinaries with a performance improvement plan, because the point is not to tell them that they messed up and to give them a bit of a whack around the head. The point is to explain why what happened wasn't acceptable and then to move forward into kind of a constructive sort of space. One comment to make before we go into some of this, employment law is formed in two ways, and this seems like a sideways step, but it'll make sense in a second. It's either formed when legislation is written by the government, so the Employment Relations Act or the Health and Safety at Work Act, laws that are passed by the government, or it's formed when judges make decisions on cases, so situations brought before them. So disciplinaries are governed by both types of law. They're not written into any of the law issued by the government. What governs disciplinaries and how they're managed are people who have tried, and sometimes successfully, but more often failed, to manage disciplinaries in a way that's considered fair and reasonable. And so a lot of the learnings and a lot of the rules come from our learning from their examples, basically, and the laws and the guidance that the judges set down. So I wanted to lay that out before we proceed, because sometimes we have questions about where in the law does it say I have to give the employee a response meeting. It does say in law that you have to do that, but sometimes it isn't written in law, it's written in case law, and so there are lots and lots of examples to back that up. So in terms of the process then, what's the process for running a disciplinary? You've decided that the behaviour wasn't acceptable, or you've decided that someone's performance has gotten to a point where the softer measures you've taken to try and manage the situation haven't been effective or haven't resulted in the change that you wanted to see. So a disciplinary is the way that you want to go. We're going to talk about the process in terms of structure, and then we'll talk about what's important to get right and what's important to get wrong. So what is the process? The process is that you have 3 meetings with the employee, and the meetings each serve a purpose in terms of giving them a chance to give you their feedback. So meeting 1 in HR language is called the notification meeting, but we can just call it the first meeting. And the purpose of this conversation is to give the employee your concerns, to present to them, possibly for the first time, if it's not something they've had raised with them before, what your concerns are about their behaviour or about their performance. So you sit down and go, hey Sylvie, I'm really concerned that you haven't been meeting your sales targets for the last 4 months. I've had catch-ups with you every month to talk about targets, to talk about actions, to make sure that you're hitting your numbers, and you haven't hit them. So we're now in a position where we're looking at taking you through a disciplinary for poor performance. Or on the behaviour side, hey Sylvie, I know that we had our Christmas party last week. You got really, really drunk and were completely out of order. You said some really offensive things to a couple of members of your team, and you were really rude to the CFO. So we're now taking you through a disciplinary process because that behaviour is not acceptable. So at the first meeting, you're having a discussion with the employee. You're also giving them a letter which outlines those concerns. It outlines what it is, how they know how their behaviour wasn't acceptable or their performance wasn't acceptable. It also outlines next step, what the potential outcome of the process is, whether it's a formal or a final or dismissal, and it outlines their rights in terms of seeking advice and bringing along a representative or a support person to the next meeting. So first meeting, you're having a conversation, you're giving them a document to take away with them, which forms the basis of the disciplinary process. You don't need to give notice for this meeting. You can just say, hey Sylvie, I have a couple of minutes with you. Can we just go and have a conversation? You can book it if you want, but the likelihood is that the employee will be set on edge. They'll be nervous, they'll be worried, and they won't, it's not a good place to be for them anyway, but it also doesn't serve any benefit in terms of pre-warning them. So our position is that you shouldn't book notice for that first meeting, or you shouldn't book that first meeting. So you've had that first meeting, the employee might be in a bit of shock if it's something they weren't expecting, or they might be a bit defensive or a bit angry. They then are entitled by law to go away and have some time to think about it, to seek advice if they want to, and then to come back to you with a prepared response to your concerns. So you can't put them on the spot and ask for their response. They get time to go away and think about it. The time frame between meeting 1 and meeting 2, which is the response meeting where they give you their feedback, needs to be quote, fair and reasonable to have given them time to seek advice. We advise starting with 2 working days. So if you have the first meeting on a Monday, having the second meeting on a Wednesday. But if the employee asks for more time, anything up to 2 weeks is considered reasonable. So we start at 2 days in between meeting 1 and meeting 2, and then we go to up to 2 weeks if, for example, they're really sick, or if you've given them a really massive letter with a lot of stuff to think about, they might need some more time. So at the second meeting then, so the response meeting, meeting 2, it's their meeting and their time really. So they get to give you their explanation for what happened. What you may do is ask questions. You might want to explore their response a bit more. So if they said to you, well, I wasn't told that I had these particular sales targets, so how on earth was I meant to meet them for 3 months? You might want to clarify and say, well, they were sent to you in an email, they were repeated to you on Slack or in other emails during the months, and I had meetings with you every 2 or 3 weeks to clarify that you understood your targets. So tell me again, or explain to me again how it was you didn't know that you had them. So you can ask questions to make sure that you understand their response, but the purpose of the meeting is for them to talk and give you their feedback. So they should be doing most of the talking, and you should just be asking clarifying questions. The employee is entitled, it's not a you're being a nice person by letting them do this, they're entitled to bring a support person to the meeting if they want to, or to bring a representative to the meeting. So the difference is that a support person is there exactly to support them. It might be a partner or a friend or a relative, whereas a representative is there to speak on their behalf and is often a paid person like an advocate or a lawyer. So be aware that there might be someone else coming to that meeting. So at the end of meeting 2, you should have a reasonable handle and a reasonable bit of understanding on their explanation for what's happened. If they have given you more context that you need to go away and investigate, that's totally fine. On the other end of the spectrum, they may just say to you, yep, I'm really sorry, I didn't meet my sales targets, I'll work really hard to improve, I've got some ideas for how I can do this differently, let's just kind of move on and get on with life. So at the end of that second meeting, and this is where it's a how long is a piece of string question, if you have someone who has given you a really massive response, you'll need to go away and investigate. If they've given you a shorter response, you can make a decision pretty quickly about whether you're going ahead with the formal warning, the final warning, or the dismissal outcome that you proposed. So the next step from there is to fairly consider what it is that they've told you, hence why you might need to take more time, and then make up your mind about what it is you're going to do next. So the third and final, is the outcome meeting, at which point you are confirming to the employee what your decision is. And whether the outcome is, I wasn't aware that you didn't know what your sales targets were, we're not going to give you a warning this time, but here's what we're going to do to make sure you hit them in the future. Or whether that discussion is, we acknowledge that you felt really stressed and under pressure, but you didn't meet your sales targets, so we're going to go ahead with a warning. Either of those are a potential outcome. You're just confirming it to the employee at that point in time. It's always good having a paper trail, so we strongly recommend discussing it with the employee, but also giving them a letter. The letter should also contain what your decision was, what their feedback was from meeting 2 and your response, or how you integrated it into your decision, and should also contain how long the warning's valid for if you've given them a warning, and what the next steps are in terms of supporting them to improve. So remember, we talked about the disciplinary not just being a punishment piece, but also being about changing their behaviour. That's where that performance improvement plan comes in, so you're supporting them to improve. That's a lot of process to kind of talk about, and there's different avenues you can shoot off as it goes on. We have a disciplinary process map that's available in the comments on this video, I believe, or will be made available. You can also download it from our website in the resources section. So please go and have a look at that to make sure that you understand the process to go through. We also have comments on the piece to make it feel a bit more human and a bit less processy, so go and take a look at that. Having talked through the process then, what's important to get right? What is the point of having this process in place, and kind of what does it do? So the main reason we have this process in place is to make sure that your employees are being treated fairly and reasonably. And it's important that that fair and reasonable process allows you and supports you as a decision maker to reach a fair and reasonable decision. So that's codified in law, and when we talk about some employment law being created through legislation and some through case law, this gets really boring, but I just want to run through it. Section 103A of the Employment Relations Act outlines that you must make the employee aware of your concerns, give them time to consider your concerns, take their feedback into account when making a decision, and then make a fair and reasonable decision about the action you're going to take. So this process actually is quite clearly laid out in law, and the requirements of each of those steps are quite easy to meet when you follow that 1 through 3 meeting step process. So in terms of making sure that your process matches what the law requires, it's really important the employee is aware of the allegations against them. Where this can get a bit tricky is where you've got someone who's made a confidential complaint, for example. We'll be talking about that more in our next Facebook Live on how to manage those situations. Where a customer has complained and said they were unhappy but didn't give you specifics, for example, it can be quite hard to go to your employee with everything that they need to make a fair and reasonable response if you don't have all those details. So that can be a challenge sometimes. It's really important to make sure that the employee has the opportunity to seek advice, hence those 2 working days in between. Just like with criminal or civil law, the employee is allowed to go and make sure that they are presented and ready to give you their response. And of course, it can take some time to get that advice or to seek that support from friends or family or from professional services. It's then really important that the employee has a chance to give you their feedback, because otherwise you haven't got both sides of the story. You are then trying to make a decision based only on what you know without taking what's happened on their side into account. So the employee needs to be able to have a chance to give you their feedback. If they choose not to do that, that's totally fine. The employee isn't obliged to give you their side of the story. You are just required to give them an opportunity to do so. So if the employee is stonewalling, if they're refusing to attend meetings, if they're not engaging with you, as long as you have given them the opportunity to give you their feedback, that's kind of your side of the story done. You've given them the chance to give you that feedback and they've chosen not to. The 4th really important thing to get right, of course, is then considering their feedback. If they've given you a whole bunch of details that you hadn't considered or hadn't thought about, go and investigate them. Make sure that you are making what is a fair decision to give them a warning or dismiss them or not give them a warning if that's appropriate. So going into it with a predetermined mindset or going into it thinking you're going to come out with a particular outcome means that you may risk getting this step wrong. Because if they give you new information, you should be taking that on board. So that's what's important to get right. On the flip side, what is it that can go wrong? What are the different things that we can mess up when we're running through a process like a disciplinary? And the short answer is that there are lots of things, as anyone who's ever dealt with humans will know. So some of the main things that we see go wrong are new information coming to light during the process. That can be information which adds to the disciplinary. So you thought the employee maybe only sent out 1 report that had errors in it. If they've sent out 20 reports, you might want to reset your disciplinary and start again, because this is now a big problem, whereas before you thought it was a little problem. Or on the other hand, you can find out that actually it wasn't the employee that sent that report, it was a different colleague, it was a different member of your team. So you now have to step it back, apologise to the employee who you brought in for a disciplinary, and then start the process with the other employee who did send out the incorrect report. What happens quite a lot is employees can unnecessarily delay their response or delay the process. This often happens when they are either trying to avoid having a meeting with you because they know that they're in the wrong, or it's happening because they've got an advocate or a representative who is advising that they drag things out and delay the process. So that can be frustrating and can often get tempers kind of hot in the room. The employee can also get a really combative or a really antagonistic advocate or employment lawyer. So when you are simply trying to figure something out, if they've got someone in their corner who's a real bulldog, that can be a real barrier to constructive conversation and can actually tilt the outcome towards the employee leaving with a bit of go away money in their pocket rather than resolving it and actually kind of carrying on with a productive relationship. So getting a combative representative can be problematic. The other thing that can go wrong is that you as the business owner or the decision maker can predetermine the process and miss including their feedback. That happens when it appears like quite a cut and dry case. Perhaps you have video footage of them taking money from the till, or you've got someone you really trust who's reported that they were stealing meat from the cooler. When that happens, you still have to go through that process. You can't shortcut around it because you've got video footage or a really reliable kind of testimony that they've done something wrong. So making sure you follow that process is as important as making sure you have good grounds to kind of carry on with it with. The other thing that can go wrong, or one of the other things, is that you can just say to someone, I'm giving you a written warning, Sylvie. and not consulting with them about it. An employee is entitled to be consulted with when it's something that might affect their employment. So going straight to the outcome without going through this process means that if they raise a personal grievance against you, they'll win. It's pretty cut and dry on that front. The other thing that goes wrong sometimes, not as often but sometimes, is that the employee has a great explanation for the issue and you look like a bit of a vindictive boss who's gone straight for the throat in terms of managing the issue. So this is where your pre-work becomes really important, making sure that you have genuine grounds to proceed with a disciplinary rather than just being a problematic kind of aggressive manager of the situation. The other thing that can go wrong at the end of the process is that the employee has a fundamental employment right to raise a personal grievance, and if you have missed any steps in the process, or if your process has not been fair and reasonable, or if the way that you manage the situation was not appropriate, they can raise a grievance against you and you might be on the hook for a bit of money. What's really important in all of those situations where the process is being deviated, someone's delaying, there's a really combative lawyer, whatever else is going on, is staying calm, not losing your temper, publicly at least. You can have a bit of a cuss when you get home. Remembering to treat the employee fairly and sticking to that process as much as possible. It's really easy to get partway through, you're trying to run a business and manage a day job on the side, and managing this admin can just be a bit of a hassle, and it can be tempting to throw your hands up and go, I'm done, I just want them gone, I'm going to tell them to get lost. It's hard, it's emotionally draining. So making sure that you keep your temper and your patience will mean that you have more options to get out of it later on, rather than being kind of backed into a corner because you have said or done something that you can't really recover from. So we've talked about the process, we've talked about what we need to do, we've talked about what can go wrong. How do you manage from there? What's the next step? So if you've used a disciplinary as a corrective tool, hopefully the behaviour improves and you don't have to go through this again. Hopefully the employee acknowledges that yes, getting too drunk at the Christmas party was a bad idea and they will be more mindful of their consumption going forward. They might acknowledge that they need some help meeting their sales targets, and so they engage with you on a performance improvement plan to make sure that behaviour happens. The point is to course correct from something going wrong to something going right so that you can have a productive relationship with them, and hopefully that's the outcome. If you otherwise have a good relationship with them, if you wrap around support to make sure that they're achieving, that should be where you land. On the other hand, you just might have lost patience. This might have been the 4th Christmas party they got really drunk at. They might have some issues with their relationships with people in the team. You might be fielding complaints about them all the time. It might be the 12th month that they haven't met their sales targets, and you're just committed to getting them out of the business, really. So if that's the course that you're committed to, managing someone out of a business using consecutive disciplinaries is called performance management. It's different to performance reviews, which are a positive process. This is very different. You're basically closely holding someone to account quite consistently, with the expectation, really, that they will not meet your expectations, and then you can move them out of the business. So we'll talk about that for a little while, because it is one way to get people out of your team. We advise that you have 2 written warnings in place before you look at dismissal for either misbehaviour or misconduct, or for continued poor performance. So the first of those disciplinaries would be a formal written warning, so the lowest punitive level. The second of those would be a final written warning, indicating that this is the final spot before you look at firing them. And then your third disciplinary process can be dismissal on notice. It usually takes 2 or 3 months to get there using this process, so it can be a bit painful, especially if you've got someone who's causing immediate problems in the team. So if this is your situation, give us a call and we can talk you through all of your options, just to make sure we're not sending you down a path that's going to take longer than it needs to. So formal written warning, final, and then dismissal. As a side note, we don't recommend using verbal warnings, and we hear about them a lot, especially from the trades clients that we deal with. The reason for that is the case law, part of the law, has established that in order for a warning to be fair and valid, there has to be that consultation process. Verbal warnings are often given on the spot or after just a chat with someone. They don't stack up as having been a fair and reasonable process, so you can't rely on them to then go to dismissal after that. If you're going to consult, it may as well be in writing so that you've got a paper trail, and it may as well be a formal written warning and then a final and then dismissal. So we don't recommend using verbal warnings. The reason we say that you have to have warnings in place at all before firing someone, if someone's a dick and they're not performing, can't you just get rid of them? The answer is no. The judges in their infinite wisdom have decided that someone needs warnings that their behaviour needs to change before it's fair to fire them. So it would not be fair to fire someone on the first offence or when they weren't aware that their behaviour was a problem. So in order to manage against that risk, the way to manage it is going formal and then final and then dismissal after that. So there must be warnings in place before you fire someone for poor performance. That doesn't apply when it's something like serious misconduct, which we'll talk about at a separate session, but if it's a performance-based dismissal, then you will need to have those warnings in place. So we've talked a lot about disciplinaries. What are the other options for managing a difficult relationship? We'll talk about those for a second. So as I mentioned at the top of this discussion, you can always have the choice available to you to tell someone to get lost, that you don't want them around, to collect their stuff and go. You can do anything in employment law. What you can't do are avoid the consequences for those choices. So like I said, it's illegal just to fire someone on the spot, but if you think that the damage they're doing to your team or to your business or to your clients is significant enough that you're happy to take the risk of potentially like a 3-month salary payout plus costs plus lost wages, that might be a choice that you make. And lots of people make that choice all the time. It's just about risk management and prioritizing what's more important to you as a business owner. So you can always do that. Managing it more softly is something that most business owners and managers will do anyway. If they have some concerns with an employee, you're much better to catch that as soon as possible so that you can say that you, hand on heart, were giving them fair feedback that their performance or their behaviour wasn't acceptable, and then from there kind of managing it up the chain of seriousness as you need to go. Humans and people, I don't know why I say humans, we're not getting camels in to do our work. People in jobs generally want to do a good job. They generally are committed to making a good go of it because if their job is going well, they're happy for 40 or 45 hours a week. You will run up against people who don't want to improve and don't want to change, but giving your team the benefit of the doubt and having that conversation with them first is almost always where we first advise our clients to go. Because if you can resolve the issue with a 45-minute conversation and maybe some catch-ups afterwards, that's a really positive interaction and it saves you a lot of time and a lot of hassle. So that's where we always recommend our clients go first. If that hasn't worked and this person is still being challenging, whether it's in the performance space or on the behaviour space, you can manage it much more formally with them. And that might involve having using what we call a record of discussion. So it's a conversation that is formal, there are notes written down, you both agree to some actions, you both sign, you both get a copy of the notes. It very quickly changes the tone of a discussion from, hey Sylvie, I'd like to give you some feedback, to this behaviour is not acceptable and here's what we're going to do to change it. So a record of discussion can be a good place to go. You can also move straight to a performance improvement plan if things are getting quite problematic. So I mentioned performance improvement plans in the context of using them to wrap up a disciplinary outcome. You can also go straight to them if it's something that you would like to do and you think's fair in the situation. So those can be really useful. You can also, at varying points in managing this relationship, offer someone some go-away money. That's often a settlement where you've come to either a kind of an impasse, you can't agree on next steps, there's conflict about how you're trying to manage things. There is almost always the option in some shape or form to pay someone money to go away. It's just about finding a figure that you're happy with and finding a figure that they're happy with. And if you can't do that, you need to have been quite mindful about how you open that conversation, but that's an option available to you as well. If you are considering paying someone money to go away, please give us a call or give your consultant or your lawyer a call. There are a lot of fishhooks because the law, quite understandably, doesn't want employers going, here's 10K, can you just go away now? That's not how they want us to manage our relationship, so there are some hooks around it. So be mindful that you can't just open that conversation out of nowhere. There have to be some process steps that you go through. Okay, let's wrap up. There was a lot of content in there. So to summarize kind of the points today, relationships with your team can turn sour or go south for a whole host of reasons. And an ounce of prevention is always going to save you that pound of cure down the line. So having conversations early and proactively is always going to be what we advise. And keeping things with your employees positive can be a challenge, but pays dividends down the line. You should try all or most options available to you before going down the route of a disciplinary. It should be a tool for corrective behaviour, not as a punishment piece. And there are other ways to manage poor performance that doesn't, or misbehaviour that doesn't involve giving someone a written warning, which can be quite demotivating. They are tools for managing, right? So the intention is to fix the issue, hence why you want to wrap it up with a performance improvement plan. If the behaviour changes or corrects, that's great. That's exactly the point of managing the situation. And if not, you have the option of managing them out using continued disciplinary pieces. Or if you want to manage it a different way, you can pay them that go away money or just tell them to get lost, if that's your choice. The overall takeaway, if I could give you one little piece of information to take with you, is that the process by which you manage your concerns is as important as the concerns themselves. So you need to be really, really careful about making sure that you are treating your employees fairly by following the 1, 2, 3 meeting process or something similar if there are deviations, because even if you have video footage of your employee punching a client, you can't just fire them on the spot. There are steps to go through and to manage them. So that would be my one takeaway. We've now covered kind of the formal content section for today. I'm just looking up to make sure that we've got some questions going on. I will grab my phone and then I can answer those. Oh, thank you.
So just scroll down.
Sweet. So I've got a question from Alex. Hi Alex, thanks for watching. In regards to bringing an advocate to the meeting, is the employee at any point liable to pay for this person, i.e. a case in which the employee wouldn't attend without a mediator and we were requested to pay? That's a really great question, and it kind of depends on the context. So if you have said to the employee, we're going to take you through a disciplinary process, and the employee chooses to bring an advocate or chooses to bring a consultant or a lawyer, the employee is required to pay for that person. You're not obliged to pay for them to have someone to come to the meeting. So if they've made the choice to have a person come along, they're responsible for paying for them. Where that situation is slightly different is if you either settle with them out of court and you agree that you'll pay a contribution towards their costs, or if they take a personal grievance against you and it goes to the Employment Relations Authority. If you lose that case, you will have to pay for the employee's costs because you were in the wrong and your behaviour was what drove them taking a personal grievance and then incurring these costs. Likewise, if you win the grievance and they lose, then they'll have to pay your costs, so it does go both ways. But most of the time, in kind of general response situations, you're not obliged to pay for the employee's support or advocacy because they're responsible for doing that. Cool. Question from Vic. Hey Vic, how are you doing? Can we please talk about what is acceptable in terms of the support person speaking during the meeting, asking questions and so on? Totally, that's a great question. So it depends on the capacity in which that person's attending the meeting. So if they are there as a support person, it might be their mum if they're a young employee, it could be their partner, it could be a friend. If they are there as a support person, they do not have the right to speak on behalf of the employee. Often you'll get people cutting in and sometimes attacking you as the employer, sometimes pushing back on what it is that you're trying to do. As the employer, you have the right to say to them, look, you're speaking a lot on behalf of Sylvie. You're here as a support person is my understanding, so I need to hear from Sylvie about what happened with her sales targets for June or whatever the situation is. And if the support person keeps interrupting, you can adjourn the meeting or call it and then bring the meeting back together, or hold the meeting without the support person present if that's what they're doing. If the person attends though as a representative, this tends to be lawyers, employment consultants and so on. They are there to speak on the employee's behalf. So cutting them off is not advised because you'll antagonise them and make them more committed to getting some money out of you. So if they're there as a representative, they can speak on the employee's behalf. If they're just there as a support person, they can't, or they're not meant to. So it can be, it's quite important to clarify at the start of a conversation in what capacity they're attending, and then you can kind of manage them interrupting or speaking from there. Question from Chelsea. Hey Chelsea, what would you suggest the process is if the employee does not show to the meeting? How many times do we need to reschedule? Great question. So I said before that your obligation is only to give them the chance to provide feedback. So it depends a little bit on their reasons for delaying the meeting, the response meeting, so meeting 2. If their reason is that they had a kid who was really sick and so they haven't had time to find a lawyer, or they haven't had time to prepare, we'd advise giving them a bit more time to prepare that response. Anything up to 2 weeks is considered reasonable. If it's their lawyer who's, away on holiday or is not around or for whatever reason can't attend, you can force the issue a bit sooner than that. Long story short, if it gets to the point where you have given them multiple opportunities to give you their response and they've delayed or not attended or whatever's going on, you can say to them, our obligation is just to give you the chance to give us feedback. You don't have to give it to us. If we don't have a response from you by close of business tomorrow, we will consider that you have said everything that you wanted to say, and we'll proceed to make a decision with the information available to us. So just to recap, you can draw that line in the sand. The point at which it is reasonable to draw that line depends a lot on what else has gone on. So it's case by case, but there is that line there to draw once you've kind of got to that point. Another question from Chelsea: to terminate someone through consecutive warnings, does this need to be for the same behaviour? Great question. No, it doesn't. So if you have someone who didn't meet their sales targets and you got them onto a formal written warning, and then they were reckless when they were driving the company car to a sales appointment and then crashed the car and it was their fault because they were playing Candy Crush on their phone, you can get them to a final there, and then the next time they mess up, that can be dismissal. So you can have the 3 or the 2 warnings in place for different behaviours and then move to dismissal. The alternative world there would be that you had 1 warning in place for lateness, 1 warning in place for errors, 1 warning in place for not meeting their targets, 1 warning in place for a car. That's not reasonable for someone to have 8 different warnings in place before you move to terminate. They can be for different behaviours. Chelsea again, instead of a verbal warning, would a caution be appropriate, and does a consultation need to be had to issue a caution? They're the same thing. There's nothing materially different. In order to have a warning in place that you can rely on to then get to dismissal, there has to be consultation. And if you want to consult and then call it a caution, you can do, but you may as well call it a warning because that's a firmer name for it and it gets you closer to that dismissal piece. One last question from Chelsea so far. Thank you for all your questions. It's great to have this discussion. Can someone request to record a meeting? Yeah, absolutely. So if someone is attending who's a rep or an advocate, they might ask to record the meeting. They need your permission to do that though. So if you're not comfortable with the meeting being recorded, you can decline. Likewise, you can't record a meeting without the other person's permission. So if you both agree it should be recorded, that's totally cool. Usually the person who's recorded the meeting will share that recording afterwards, but you need to get both sides approval. And if one of you says no, then you can't record the meeting. Cool. Great questions, everyone. That was everything from now. If you do have any other questions, please feel free to post them on the video afterwards. I'll be sticking around for a while to answer those questions. You can also drop us an email at info@myhr.co.nz with any other questions to explore. Just again, this video will go up on our YouTube, Facebook and LinkedIn pages as well, so you can access it afterwards. Thanks as always for your time. It's been great talking to you and getting your questions. Hopefully you got some value out of the session, and we'll see you again next month.